Have a seat. Have a seat, sir.
Take it.
I'm just trying to be nice.
Nice is with actions as well, right?
I will compose myself properly, sir. And I would like to apologize to everyone in the court. I'm sorry. I'm trying to. I'm innocent. I am innocent. Read the original police report. I'm innocent.
Calm down.
I am innocent. I will not comply with this. I'll behave. Oh, I debated not coming because this is scary.
We had a pretty wild scene in court recently. A man, clearly frustrated, ended up chasing after the judge while shouting that he was innocent. It was chaos. By the time it was over, his shirt was stretched and partly torn. Whatever message he hoped to get across was completely lost in the shouting and poor choices. Courts aren't a place for outbursts like that. Acting out like this can lead to serious consequences, like being charged with contempt or even facing new charges in addition to the original ones. And if you're trying to prove your innocence, causing a disruption isn't exactly the best strategy. Let's take a look.
Have a seat. Have a seat, sir.
Take it.
Can I get my phone? No. I can't handle a paper? Are you joking? I'm getting sued over Don Disso. Look at the paperwork. Don Disso.
Can you mind staying on?
Sir, I'm so sorry, sir. I don't know. I'll behave. I'm sorry. Oh, you tried to smile a little bit.
Oh.
I saw that.
You know what I say about composing?
Okay, sorry. I'm just trying to be nice.
Right. But nice is with actions as well, right?
I will compose myself properly, sir. And I would like to apologize to everyone in the court. I'm sorry. I'm trying to.
Stephen, just.
No.
Can I say so? I'm not trying to be
How would you yell first like this?
I'm innocent. I am innocent. Read the original police report. I am innocent.
Calm down.
I am innocent. I will not comply with this.
If I may, are you letting him out?
I'm going to let him out. I just need him to calm down and just trying to do whatever he wants to do. Whatever, you know?
Are you letting him today?
No. I want to let him out today. Let's just give him another 30 minutes. Just
I've got to go see the courts.
give him 30 minutes and then hopefully we can.
Well, what's right?
Hey, can we bring him out, you think, or not? Steven's back there? Okay, yeah, do you mind?
Did our guy come down?
He came out here with the lack.
Yeah, I was here when he came out and he was, I'm innocent. At least he has his clothes back on. Did I check on him? No, I assumed the bailiff had that under control in the back.
What they say about assumptions, huh?
Yeah.
Hey,
How's it going?
good.
I'll behave.
All we want you to do, Mr. Rabode, is give your side to Mr. Slider. Okay, he will help you work with this case so it can get the best result possible. Okay, understand that we don't appreciate when people come from over there all the way over here because it's very possible that I didn't even see that you were here.
I'm sorry. I didn't mean to sneak up on you. I'm sorry.
The problem is that not everybody is as nice as you. What happens if someone comes and tries to attack me here? You know what I mean?
I'm sorry if that's ever happened.
So that's why it scares me.
Okay.
You come up this way. I didn't even see you until Steven looks at me and starts darting this way. I didn't even see you, and it scared the crap out of me.
Well, I'm sorry. I didn't mean to scare you, sir. Okay.
It's okay. And look, I don't think you mean any ill will. Otherwise, you wouldn't be here, right? But
Oh, I debated not coming because this is scary. Like, it's scary being here. I don't like being here.
what I meant was, if I thought you meant ill will, I would already have you in jail.
Okay.
Right.
I appreciate you not locking me up. Thank you.
Of course not. I don't want to lock you up. I don't want to put you in jail. I don't want anything bad to happen to you. Just understand we have a certain way that we handle things here, right?
May I say something?
I don't say that.
Not about the case.
It's not about the case. I just want to say, and it's in the paperwork, I've already been in jail over this. I've been put in jail over the weekend. I have the paperwork from the first time I went to jail. And, you know, I'm kind of curious why I went to jail because I didn't do anything.
I'm going to let Mr. Slider explain that to you. Okay. So just be wary that all I need you to do at this point is stay in contact with him. I'm going to waive the appearance for the next time. You don't have to come here. Okay. All I'm asking you to do is stay in contact with him. If he comes back to me though and tells me he can't get a hold of you, I will issue a warrant. And I'm going to tell you, I will not give you any more PR bonds. So all you have to do is stay in contact with him. And if you do, good things will happen for you. And one more thing, don't pick up any new cases.
I'll try that. I won't.
I don't think you will, but just remember, not everybody's patient, okay? Anyways, all right. Okay,
Thank you, Judge.
all right, please. Mr. Road, best of luck to you, sir.
Thank you.
For sure.
Look at what happened and talk about it. Do you think this was a case of someone struggling with their mental health or just someone making very bad decisions? Let's watch and see for ourselves. Now, let's talk about something we keep seeing, people who call themselves sovereign citizens. If someone could explain why these individuals feel the need to challenge even the most basic parts of a legal process, like saying their name, I'd appreciate it. It's baffling. A lot of these folks seem to get their ideas from internet, videos, especially about outdated or misunderstood legal concepts like maritime law. Some of them even believe that because they view the US as a corporation, they're somehow not subject to its laws. Unfortunately for them, courts don't accept those arguments. In
I
fact,
reserve all my God-given rights. I waive.
Let me let you in on the secret.
I'm not representing myself. I am myself.
Your appearance,
Good morning, Judge McNally, Cezanne Barta, P65425 on behalf of Bank of America.
your name, sir?
I, Patrick Shanley, am before this court by special appearance.
Hang on,
Without waiving
hang on.
any rights,
Mr.
remedies, or
Shanley, Mr.
defenses.
Shanley,
I am not waiving defects of services, nor am I submitting to the jurisdiction of the court or the alleged plaintiff
I didn't
in this
ask
cover
you.
of law action.
I didn't ask you that.
I
asked you-
reserve all my God-given rights. I waive.
Let me let you in on the secret. I'm going to listen to you, but I'm not going to play games. I asked you for your appearance. I read your briefs, period. I didn't ask you to go on like that. Don't do it again. But you can proceed on your motion to dismiss counterclaim. Congratulations, Mr. Shannon. That's the first time I've used that in years. Go ahead.
Your Honor, I'm hoping this ends today. There are two motions before you. One is to quash the matter against Weber and Olsey and the 5 named defendants from my office. I believe the last time you were here, brother counsel, Mr. Werber, that was here, he advised me that you told Mr. Shanley that he needs to hire an attorney because he was treading on some dangerous water. And he has not hired an attorney.
Well, I didn't say he needed to. I strongly suggested
Yes.
that he do that.
Because he was treading on some dangerous water in the claims that he's making. We're asking for the matter before Weber and Olsey and the 5 named attorneys to be dismissed at this time, Your Honor.
If you don't mind, I'd like to take the motion to dismiss the counterclaim first that was filed, and I understand there could be reason for confusion. Your office filed 2 separate motions. You filed a motion to dismiss the counterclaim, which focused on the claim that Mr. Shanley has against Bank of America as Bank of America being counter-defendant. And then you filed a motion to quash summons and dismiss 30 third-party defendants on the claim that Mr. Shanley has against the law firm Weber and Olsey's PLC, which really should have been, as you know, a third-party complaint, and then as against the individual lawyers that I already mentioned, which would include yourself, Michael Olsey, Michael Kirschenheiter, Jeffrey Werber, and Sandra Francis. So let's proceed first.
I object.
You can object all you want. Let's proceed with the motion to dismiss counterclaim.
I object.
I'm telling him I want him to argue that one first, Mr. Shanley. What are you objecting about, besides the fact you just want to get loud?
I have my affidavit before you, the paperwork. That's what matters in this case.
Mr. Shanley, I have two motions. I'm going to listen to what you have to say. I'm telling him I want him to first proceed with his motion to dismiss the counterclaim that they filed pertaining to your claim against Bank of America. Then after that is argued by both parties, he can go on to the motion to quash the summons and dismiss the third party purported counter defendants or third party defendants, both the law firm as well as the individual defendants. That's all I'm saying, sir. There's no reason to object about anything here.
In fact, judges are allowed to completely disregard these types of objections because they're legally meaningless. Some of these people speak in confusing legal terms that don't actually mean anything, and frankly, it's tough to watch. It's like hearing a voicemail scam play out in real life. But let's continue and see what else this particular individual brings up next. Now here's something that doesn't add up. Many of these same people apply for credit cards and use them regularly, but then claim they're not responsible for the payments because they didn't agree to the contract. One man even argued that he wasn't a real person, and therefore the rules didn't apply to him. That's not a legal defense. It's the plot of a rejected science fiction movie. The reality is simple. If you sign up for a card and use it, whether it's for groceries or dinner, you're responsible for paying it back. Courts have made it clear time and again that I don't consent doesn't hold up when you've already accepted.
Go with your motion.
Your Honor, our motion, we're going to rely on our written brief. However, I'm going to make it very short. He solely relies on that verification was not met by Bank of America, but Bank of America did validate.
I object. He can't speak for a fiction.
Sir. This is a courtroom and we show one another courtesy. You will have an opportunity to respond to whatever he has to say when he's done, okay? Be glad to give you all the time you need. Go ahead.
Your Honor, Bank of America is not considered a debt collector, and the FDCPA only pertains to debt collection companies. So the FDCPA does not apply to Bank of America. And his sole claim is that there's a violation of the FDCPA. But if Bank of America were deemed to be a debt collector, they still verified the debt to Mr. Shanley and sent all relative documentation. The fact that they did not provide Mr. Shanley what he believes they should have given him is not a violation in and of itself as well. So, and that's the sole reason he filed his counterclaim against Bank of America. And it just does not hold water at this point.
All right, Mr. Shanley, your response.
Have you read my affidavit, sir?
I'm not a witness. I'm the judge. Of course, I've read everything in this brief.
Everything I have to say is in my paperwork in there.
So here's what I'm left with. On July 21 of 20, it appears to the court that the defendant counter plaintiff entered into a contract with plaintiff counter defendant Bank of America. Also, the claim is that Bank of America failed to validate the account. The court is going to rule in favor of Bank of America and dismiss the defendant / counter plaintiff's counterclaim versus Bank of America for the following reasons. Bank of America is a creditor. They are not a debt collector, and they're not subject to the FDCPA. Therefore, as such, we failed to state a claim upon which relief can be granted, and their motion is granted pursuant to MCR 2.116C8. Moreover, there's documentation attached to the counter defendant's response that indicates that one of the lawyers.
Your Honor, I've submitted my affidavit, which rebutted their Bank of America. My paperwork reads for itself. All that other stuff was hearsay. I have this affidavit. Are they gonna rebut my affidavit?
Okay. Do you have any response to that, counsel?
No, Your Honor.
Your affidavit talks about you're not an artificial person. Affidavit of status of Patrick Allen Shanley, right? What are they supposed to rebut in here? You're referring to the affidavit attached to your motion to dismiss, supported by affidavit of Patrick
Yes.
Shanley? Okay. All right. Well, you guys can have a seat. I've told you, Mr. Shanley, they don't have to produce a contract. They don't have to produce a written contract. When you use the credit card, the contract is formed, period, plain simple. And then you're subject to the terms and conditions of the credit card agreement.
Did the terms through your actions. This kind of thinking isn't just legally incorrect, it's financially reckless. Let's keep going and see what else comes up. If anyone out there considers using these sovereign citizen arguments in court, please don't. They don't work, and they'll only make your situation worse. Not only are judges not impressed, but many of them have become pretty fed up with these claims. In fact, courts across the country have ruled that these arguments are completely frivolous and have no legal merit. For example, one person thought he could get out of legal trouble by claiming he wasn't a real person and objecting to everything the judge said, even his own birth date. That's not how the legal system works. You can't reject reality and expect...
Now, that concludes this hearing. You wanted to move for sanctions. What do you have to say about that?
Your Honor, other than the time and effort that has been put into this matter in responding, there's another case coming down the pipeline. I don't know if Mr. Shanley's been served with that case. It's another Bank of America case. If you do not award sanctions of any kind, then I don't believe it would be fair for the attorneys in my law firm at Weber and Olsey's to have to put additional time and effort on the next case. So I believe it's imperative that you grant the sanctions at this time, so that this doesn't happen again.
Mr. Shanley?
Your Honor, the last time I was here, you lectured me on that I should
Get a lawyer.
get a lawyer and pro se. Okay, I'm not doing this pro se. I'm not representing myself. I am myself. I have an affidavit there that rebuts Bank of America's claim. It's in my paperwork.
I was trying to do you a favor, Mr. Shanley. I was trying to tell you, please consult with a lawyer so you don't proceed with lawsuits that are frivolous in nature and force the court to do something that I don't want to do. That's what my purpose was in telling you that you should get an attorney. You have every right to represent yourself, whether it's a $5 lawsuit or you're representing yourself because you're charged with a serious felony. Every defendant, every party in this country has the right to represent themselves, just like I have the right to give myself a root canal. I have the right to fix my arm. I wouldn't do it. I told you nicely, I think on this case, I've only seen one or two people do it adequately in my 28+ years on the bench and my 11 years as a lawyer. But that's neither here nor there. You have that right. The problem is here that you're abusing this system. That's what you're doing. You are abusing this system In my view, and the court finds that the primary purpose in initiating this action against these lawyers in this law firm was to harass, embarrass, or injure those individuals and that law firm. You had no reasonable basis to believe that the facts underlying the party's legal position were in fact true. And I'm finding that you advanced a frivolous claim in conjunction with that counter complaint that you filed. Period. I'm not going to award it on the counterclaim versus the bank. I am going to award sanctions on the counterclaim that was filed against the law firm and the individual lawyers. You don't get to do this. This is not some kind of a game. We don't think this is funny. I have a great sense of humor when I'm not in here. Not in here. This isn't some kind of an entertainment exercise. Now, the question is, what kind of sanctions are you entitled to? And that's what you're going to have to grapple with, because even though I think his conduct was outrageous, and I do think it was outrageous, and this record should reflect that this court finds the conduct was outrageous. What sanctions is a law firm entitled to when they represented themselves, Mr. Barr? Had you gone out and hired another law firm and paid them $400 an hour, a very experienced law firm would have no difficulty in awarding recoupment of those attorney fees. The question is, what kind of reasonable attorney fees is one entitled to? And what types of sanctions is one entitled to when they've represented themselves? So here's what you're going to do, please. And it does not have to be lengthy. You can do it by Zoom, but you're going to prepare an order granting the motions for summary disposition based on the grounds I stated previously, just here 10 minutes ago. Then I'd like you to file a motion. It doesn't have to be lengthy, but you're going to have to set forth what sanctions you believe that you're entitled to. To the extent that you believe that you're entitled to attorney fees, the law firm can set forth how much time was expended, what their hourly rate was, and why those attorney fees would be reasonable under the circumstances. But I have to tell you, I'm going back to whether or not it's appropriate for a law firm to collect sanctions that's representing itself on a frivolous action that's filed against it. My gut says it should be. My brain says I don't know that it can be.
Are you going to rule on my motion to dismiss?
I'm denying it for the reasons stated.
I object.
I know. It's okay, you can appeal. I'm not always right, Mr. Shanley.
Your Honor, I have two
We have an established
Proposal.
jurisdiction.
All right, listen, I don't want to hear it. You can take all this transcript and go to a reviewing court.
To win in court. Instead of relying on internet myths or outdated conspiracy theories, maybe it's better to just follow the law and take responsibility. There are smarter, more constructive ways to handle legal issues. Let me know in the comments. Do you find these cases entertaining, or are they more worrying than anything else? Thanks so much for watching. Take care, everyone.